Okay, welcome to our last panel of the unclassified portion of the conference. Now, here at USAFA, as with all the service academies, we love boxing and just combatives in general. And anytime we can get two worthy adversaries into the ring, we attempt to do so. So with that in mind, I'm particularly eager to listen to the MILAMOS and WOOMERA, a discussion of operational art and the two primary space law manuals. Moderating this panel will be Major Brian Green, who is the Chief of Space and Operations Law for Space Training and Readiness Command. Major Green holds BA degrees in Political Science and Interdisciplinary Visual Arts from the University of Washington, my alma mater, and a JD from the University of Virginia and an LLM from the McGill University Institute of Air and Space Law. Over to you, Major Green.
Thank you, Professor Biller. Well, good afternoon, ladies and gentlemen. I am very pleased to have the chance to moderate this distinguished panel for you today on the two different military space law manuals that are in production and nearing publication. These include both the McGill University sponsored manual on the international law applicable to the military uses of outer space, or military operations in space rather, or MILAMOS project, as well as the WOOMERA manual. To introduce the panelists to you, Mr. Gilles Doucet is an independent space security consultant and president of Spectrum Space Security Incorporated. He has, prior to his private consulting, over 35 years of experience as a scientist in the Canadian Department of National Defense. And he's also a member of the editorial committee and lead technical expert for MILAMOS. To Mr. Doucet's left is Colonel Matthew King, Deputy Legal Counsel and Chief of International and Administrative Law in the Office of the Chairman of the Joint Chiefs of Staff. He has participated in both the MILAMOS and WOOMERA manual projects. Online with us is Lieutenant Colonel Michael Dupenloup, who is a human resources manager for the French Ministry of the Armed Forces. And he has participated on the MILAMOS project from 2015 to 2018, as well as the WOOMERA manual since 2018. And then finally, it's my pleasure to introduce Mr. John Goehring. It's also Lieutenant Colonel John Goehring in the Air Force Reserves. And Mr. Goehring is a Assistant General Counsel for the National Geospatial-Intelligence Agency, as well as the individual mobilization augmentee to the Staff Judge Advocate at Buckley Space Force Base, Space Base Delta II. And he is also a MILAMOS contributor. So with that introduction, I'd now like to turn it over to the panel and start with Mr. Doucet. Why is there a need for space law manuals such as MILAMOS and WOOMERA?
Okay, thank you. Thank you, Brian. Before I answer the question, I'll just give a short little overview of the MILAMOS project and McGill manual in case everyone here is not already familiar with it. And the story starts around 2010 or 2012. And it starts with, I have to acknowledge, Duncan Blake from Australia. And at the time, some of you know him quite well. He was a Royal Australian Air Force officer, legal counsel, and he was doing his LLM at McGill. It might have been around the time that you were there or close to it, right before. And so part of his research was investigating the need for such a manual. So he wrote a very convincing thesis on why outer space needs a manual of interpretation of law for military activities. There are manuals for naval operations, air and missile operations, and then the Talon manual of late for cyber operations. So the genesis comes with Duncan Blake. His thesis was so convincing that McGill decided it's a great idea. We should start mounting a project. So in 2016, McGill set up this project, gathered up numerous experts and institutions from several countries and decided to start working on this. So MILAMOS stands for Manual of International Law applicable to military use of outer space. So since 2016, we've been having meetings and conventions and arguing about all sorts of aspects relating to sources of law and applicability and interpretation of that. One of these we had in 2017 in this really nice facility here. And I remember being in those glass rooms in the middle of a lot of arguments. But at the end of the day, we're now here, and the manual, the McGill manual is being produced in 2 volumes. The first volume, volume 1, was released last summer. It's available to the public. If you Google MILAMOS McGill, you'll find it. And it contains what we call the black letter rules. There are 52 rules, which are clarifications of international law on various space law topics of importance or interest to the military. And volume 2 will be the black letter rules with associated commentaries, quite detailed, which provide the legal basis for the rule, various aspects, points of contention, and that sort of stuff. And that's hopefully will be published by early fall of this year. Now, why the need for 2 manuals? It's a bit historical in the fact that you mentioned both Mickaël and my colleague here, Matt worked on both the MILAMOS and the WOOMERA. It started out as one project, one big project to look at the issues relating to 3 different types of domains or of times. Times of peace, times of rising tension, which is basically still peace, but a bit challenges to peace, and then times of armed conflict. Now, when you have armed conflict, in the time of armed conflict, then all the IHL law regime comes into play, and where it doesn't come into play at other times. And so that made it a very wide scope for the manual, a lot of difficult issues to try and sort out. And at the end of the day, the project was split into 2, with the MILAMOS side looking at times of peace and challenges to peace, which did not include IHL. And then the WOOMERA manual, well, Matt can talk more about it, but is for space operations, all encompassing space operations, which includes IHL legal regime. So the 2 manuals, I think, are complementary. We have parts where we will overlap on issues, especially when it comes to issues of perhaps interference, use of force, principle of non-intervention, rights and obligations of states. But there are also issues which will be individually different in the 2 manuals. So that's why I think we need to, at least why we have to, as opposed to why we need to. Okay. Thank you.
And then, I could ask each of the additional panelists in turn, could you please describe how you became involved with your various projects and what the work on these manual projects looked like?
Yeah, sure. I'll start off. And first, I'll just echo the disclaimer that everyone has. You know, we represent our personal views here. And I'm not even sure I represent the views of the WOOMERA manual because we have a lot of diverse views. And I think that's what's important about it. And I should note, all of us who participated we're also just reflecting our personal views. So, you know, this was, we gathered people from, you know, academia, from various parts of governments, ministries of, you know, state foreign affairs. We had some folks from, you know, the launch, NASA or other launch agencies, and certainly people from the ministries of defense, you know, DOD, uniform and civilian. And I think we all came together to work on this. So they pulled from a large group. But it was all folks representing their own views. And so that's important at the outset. And I'll kind of jump back to your first question. Why is this important? I think it is important, not because even with this large group of people that we can say what the law is, but I think we can start a conversation. And fundamentally, that's what a manual like this should and can do, is start a conversation. And I know, you know, Gilles mentioned all the past manuals that have existed. They've started conversations. You know, I have heard people complain endlessly about the Talon manual and what it got wrong. And that's great, but it started a conversation. You know, I think they did a great job. And I am sure that people will complain endlessly about the things that we have said in these manuals, both of them, certainly WOOMERA, but it will start the conversation. And then how it is used by people after that conversation has started, you know, again, it's not what states say. We are just a group of people that came together to try to do our best assessment of what the law is currently, so that A, leaves a lot of voids, but B, we are just people working in this area. We're not the states who actually write law, either through treaty or, practice with a sense of legal obligation. So that's kind of who we are, how we came to this, and just a little bit about why, at least I think it's important as well.
Echo that sentiment as well. I think one of the needs is to help identify the gaps. The ongoing open-ended working group on responsible space behaviors, one of those mandates of participants is to take stock of existing law. And I think these manuals will help to do that, so that we, in order to get to where we want to go, and identify what we need to get there, we have to have a good sense of where we're starting from. And these manuals are designed to just identify where we are without what we hope the law to be, but just strip it down to the fundamental lex lata and see where that leaves us. And that'll help us identify where those gaps are. How we can bridge those gaps is another matter, but it'll help us to get to where we want to go. But also there's a practical need as well that hopefully these manuals will fill. One of my colleagues just yesterday, who's a space lawyer, was telling me she was asked to give a briefing on why maritime law isn't used in the space domain. So I think there's an appetite and a need out there for someone who isn't a space lawyer, isn't a lawyer, isn't necessarily familiar with the law that applies in the domain, just as a go-to resource where you can have it all in one place. If I were looking for something in another domain, I'm not an expert in those, so I know where I would go, and hopefully this will do the same for space.
And Lieutenant Colonel Dupenloup, do you have anything to add? How did you become involved with these projects?
Thank you for giving me the floor. For me, everything started in 2015, in fact, when Professor Ram Jaku came into Paris in order to present the MILAMOS manual project and to convince French scholars and think tanks to contribute it. So I met Professor Jaku at that time, and we keep in touch during 1 year. And he proposed me to join the MILAMOS project in 2016. And so I jumped into it. So I spent 2 years to contribute to the drafting of the MILAMOS manual as a contributing expert. And in 2018, I decided to join the WOOMERA manual because I considered, and it's still the case, that the manual should not address issues only related with peacetime situations.
Thank you, sir. And I'd like to ask you, and then the other panelists as well, how has your military experience informed your contribution to the manuals?
So for me, I was a legal advisor, in fact, before becoming a human resources manager. During the last 15 years, I was involved into the legal issues for mainly air operations and space operations. It's began within the French Air Defense and Air Operations Command and following into the French Space Command. And in 2012, I started again I go back to the university, and I follow a master in space law and telecommunication law. And I was also involved in 2013 in the discussion regarding the EU Code of Conduct relating to our outer space activities. So all that kind of issues and experience give me the feedback to put my insight into the manual.
Mr. Doucet, how has your background working with the Department of National Defense contributed to your insights into the manual?
Well, for me, my background is science and engineering. But I've also studied space law at McGill. And so that's how I became involved, because around the same time that Mickaël was saying that the manuals was being developed, I was there, and Professor Jacou was one of my professors. So my background of having science and engineering knowledge, as well as having worked for the military, for the Department of National Defense, combined with a certain knowledge of space law, made me a good candidate for being on the panel. And I wasn't the only one. We have a number of technical advisors for MILAMOS, and WOOMERA has as well. And it's important because a lot of legal experts, some have a lot of knowledge on space operations, some perhaps more academic, may have less knowledge of space operations, in-depth knowledge of the law. And it's important to ground the thinking in how space actually works, how space operations and satellites work, what's achievable, what's science fiction, what's science. And so we serve that purpose of making sure that the discussions are grounded in the reality of the science. And also, sometimes it's necessary to translate legal jargon to explain to the scientists and engineers, oh, this is what they mean, and then vice versa, explain from the scientific jargon to the more plain language jargon. So that's our role, the technical advisors to the panels.
Colonel King?
Yeah, for me, I'll start with a hot take for this room. Maybe I think that space law might not be quite as special as everybody here necessarily thinks it is. And what I mean by that is you can't come at it as a stovepipe exclusive area of law. And so, for me, what I feel like I was able to bring to the table for this project is a background in some international law, good bit of some LOAC experience, specifically the law of armed conflict, a form of international law, but different. And certainly, as you'll note, it's an important understanding of how space law works, but also just an understanding of how military commanders think and act and what they look for, because ultimately that's what we're talking about is the military uses of outer space for both of these manuals. So, and I think it really goes back to the comments from Professor Blank on Tuesday morning, I guess, in the keynote, that it's not just about international space law. It's about the intersection of the jus ad bellum, the jus in bello, that gray area, that fuzzy law, kind of left of conflict. You have to be able to incorporate all of those things together. And so, that's the small part that I was able to bring. But, we have folks that have an incredibly deep and rich experience in international space law. And, and I can maybe help balance them a little bit. We have people with a lot of experience in intelligence law, all the different things that are part of what makes up military space operations. But you have to integrate all those all together to really, I think, get a good picture of where the law is with regard to the types of things that we do in outer space.
Well, as a practical matter, me and Ross Brown, who participated as well, he's sitting back there, and others with military backgrounds were often relied upon to kind of infuse the rules and the commentaries with military applications, because sometimes the black letter rule may seem to be unrelated to space, that the space connection, or sorry, the military connection is not necessarily apparent, but if you could find that application to draw that picture, it would be, that's what we were trying to achieve. At a more at a less practical level, but I think it's also very real, is what Professor Blank mentioned the other day, and you just alluded to. I think everyone brings something different to the table. As a way of generalizing, it's often been said that people with experience in government or military may have different perspectives and interpretations than people from non-governmental organizations or academic backgrounds. I think to a large extent that's true. I don't want to overstate it, but everyone has something to bring to the table, and our goal for the McGill Manual was to have a diverse viewpoints, broad perspective, and make sure that we found something that could be satisfactory for everyone. And it's especially challenging to do that. But that was our objective, and I think everyone contributed with what they brought to the table.
Thank you. Now, both of you have alluded to the lex lata or the black letter law that you're trying to express in these manuals. Given that much of international law, including with military space activities, has to do with state practice and opinio juris, the founding features of customary international law, how did you attempt to analyze customary international law, and how are you able to establish when rules could actually be articulated in these manuals? How do you keep the manuals on track trying to do that black letter law as opposed to making more value judgments about what the law should be?
Yeah, I'll jump in. Well, certainly there are not many, but there are a few seminal events, and you know, as was alluded to before, we kept talking about ASAT, you know, direct ascent ASAT tests, kinetic ones, and I think those were very telling events for what was said and what was specifically not said by states in the aftermath of that, particularly with regard to Article 9 and obligations there. So I think we did have some practice, some practice through acquiescence or silence, as well as some actual statements by states in that regard. And then we also looked to various all the military manuals that we could, you know, get a hold of that did have some meaningful comments on state practice in the space domain. So absolutely, it was a challenge. And I know some of the prior panelists have mentioned just the challenges with security classifications and declassification, those sorts of things. It makes it hard for the interoperability that we've been talking about, but it also makes it hard to try to divine what the law is if you're looking for a practice-based you know, approach to law. But I want to just note too, though, that you know, with Article 3 of the Outer Space Treaty, you know, incorporating international law into outer space operations, and just with the nature of how states practice their military operations, we do have obligations, you know, under the law of armed conflict, and just general obligations that states have with regard to each other under, you know, just general international law. And so it's not necessarily, the challenge is not necessarily what applies to space law, it's how it applies to space. I should say not space law, to space. So I think we do have a good basis for custom and practice in how militaries operate, how states interact. The trick was just how it applies to space. So there are rules, it was just a matter of application.
Yeah, just to add, yeah, I agree 100%. But it was one of the biggest challenges to writing the black letter rule was to try to avoid our biases and interpretation creeping into the enunciation of what we think the law is. That was a big challenge. And a lot of the black letter rules, if you go to the volume 1 of the McGill manual, some of them are just basically a restatement of a treaty article. And well, what's the big deal about that? Well, it's because sometimes we try to interpret it, but lacking some state practice and also lacking, you know, states having expressed opinions on it. There was nothing more we could do. We were left with our own opinions. We didn't want our own opinions to be in there. So they may seem, some of the black letter rules may seem rather bland and vague, but that's an interpretation of what the state of the law is at the moment. Now, the commentaries offer more information, and that's where different points of view are expressed in the commentaries. So that's kind of how we dealt with that. Yeah,
I think that's right. We had to find common ground, strip away. Often we would point to state practice or lack of state practice more often when we were trying to disabuse a particular position. And to find that common ground, it would often be stripped down to something that is very fundamental and simple and does often simply look like it's a restatement of the Outer Space Treaty, but that's where we were left. And I think that's a sign that we were doing it in good faith and did a reasonably good job of achieving our goal of establishing or identifying the lex lata.
Only one comment regarding your question. I would say that in our process to define That's those black rules. The coordination process was really important, and both in the MILAMOS project and the WOOMERA project, because as I was involved in the two manuals, I can say both are very collective and collaborative. In both manuals, everything starts with the project rule written by a given expert. And once the first draft was completed, the other expert, including the members of the edition board, review and comment the rules. And based on their feedbacks, we've got a new version of the rules, and the process follow all the way. And at the end, during a plenary meeting, all the experts in person can discuss the black letter rules. And at the end of the process, the rules is only validated when all the experts agree on its content in terms, in other terms, when it's regarded as truly reflecting international law as it applied by states, or its relevance regarding state practice.
Thank you, sir. And you've spoken to the collaborative nature of the development of these manuals. How do you think that the process involved here, as well as the substance of the manuals themselves, can contribute to cooperation in space in military efforts in the future? Just start
yes, I think it's a good example of the cooperation promoted from the first stages of the space conquest, and in both teams, we see that whatever the countries we come from, whatever our background, we have to listen to other insight, other approach, in order to improve ourselves, because only one expert can do nothing. We are nothing without the knowledge of the others, and we try to share our experience, our knowledge, in order to define the most consensual black letter rules.
Thank you, sir. Would any other panelists like to add to that?
Yeah, I'll just jump on top. I totally agree about it was great that our respective owning agencies or whomever let us participate, and that was great collaboration. But I think the other aspect of the collaboration, I think more to what you're getting at here too, is as part of the WOOMERA process, there was a state engagement aspect of it, and this is pretty unique, I think, it hasn't happened in other similar projects. And I think it was really important. And I think it was, there were 24 countries got together. It was sponsored by the Netherlands, actually. They hosted a meeting in The Hague in 2022, unfortunately delayed a substantial bit of time due to COVID. But there were countries from basically all the continents that were there. And these were not people speaking just informally or in their personal capacities. This was state engagement. So it is people representing their states giving comments on the draft rules that were made available. And part of the reason for the time it has taken to get the manual out is the laborious task of actually digesting, intaking, and incorporating these comments into the manual. So, I don't think that it constitutes necessarily, an opinio juris, and not every state gave specific examples of things. So it doesn't exactly get to practice, but it absolutely is an opportunity to reflect the views of states. Again, as the bodies that create the international law, that was very important. And I think that was very collaborative, certainly amongst the 24 there. And I hear that comments still occasionally trickle in. I believe the deadline has lapsed, but I'm sure Jack Beard is happy to take as many comments as states want to give. But I think that that collaboration, again, as states, not just as individuals coming together, is very important. And an example of, what talking about space and these things can do.
What have been some of the main themes of that state feedback that's come in? Understanding we don't have to attribute it to any particular country, but have there been any sort of predominant motifs in the nature of the feedback or particular subject areas that may not have been considered by the manual drafting teams earlier?
Well, I know, so I don't have all of the details on that. And I know that it was we're not ICRC level of confidentiality, but it is not attributable. Again, unless states want to be attributed. And I believe that in that case, they will have their name pegged to their comments. But it is interesting. I know that the manual, again, I am just a person that helped write it. I don't have to worry about such things, but I know there is a tight word count, and that seems very painful for those who are trying to operate under it. But I know, further developing this or providing more examples of that, that was certainly a theme that I saw in some of the inputs, which is great because it means that people are participating, or I should say not people, states are participating. They want to get those views in there. And I know that we're doing all we can to incorporate those. But I think that's the best detail I can go into.
With respect to your question about collaboration, I think the process of the McGill manual was in many ways like a informal microcosm of what you would get at a more formal level with respect to what I said before. It comes down to collaboration involves finding common ground, and that was one of the I think that's the process and how we tried to do that in our project is reflects a lot of the challenges that you do in any kind of even more formal level.
Just to add one more point, if I may. We didn't have in the McGill manual, we didn't have state engagement in the same way that you've described it. We've had state observers. Obvious states have expressed support for the project because they've allowed some of their people to work on it in their personal capacity, but not a direct input into any of the text or the rules or the commentaries. But I think the cooperation and the fact that we drew from a very wide number of participants and experts involving a lot of countries around the world, including all the major space powers, and that if that helps get a common understanding of what the state of the law is in operating in outer space, that if all the participants have the same view, I think that helps to potentially reduce some tensions and reduce some risk of some incidents getting out of hand. Because one of the issues, and with the fact that it's not clear what some of these issues of due regard and principles of non-intervention or interference, to what degree is permissible, not permissible, can lead to escalating scenarios. And if there's a wide collaboration, even though perhaps states officially did not participate, but it's some of their prominent members being either academic or military were part of it, then I think that can help the acceptance of states to this perhaps common view, common interpretation of some of these difficult issues in space. So that's what at least we aspire to. We'll see what happens.
Yes, sir. So you mentioned that all major spacefaring states contributed, or people from those countries were involved. I'm curious with regard to Russia and China, did people from those countries participate, and how would you describe the cooperation? Was it pretty much the same across the board, or were there any particular issues of interest raised by individuals from those countries?
So again, we had experts from both Russia and China participating. They were participating, again, in their own capacity. Just as, the US, France, Germany, Canadian representatives. And the cooperation was excellent. Once we're in the room, we were all people trying to find the right answer. Sometimes there were issues raised, perhaps from one country, which you might not have expected from another country. But these were all they didn't seem like politics. They all sounded like very careful questions relating to the law, and they were all based on the legal existing law, either treaty language, state practice, or other conventions. So the cooperation was excellent.
Any other observations from the panel?
Well, I would add that they're excellent lawyers all around. And going back to the point I made earlier, where sometimes you have people bring different perspectives. Sometimes there's perspectives you might not necessarily expect. Like just because someone's from this place or that place, your perspective isn't necessarily shaped by where you come from. It might be shaped by other aspects of your background. But sometimes you might be making the same point that someone else is making, and you wouldn't necessarily expect that to be the case, but that happens quite often.
Were there any issues of particular controversy during the drafting of these manuals that took some extra effort to work through?
I mean, it felt like, particularly at the early stages when we were, as Michael kind of laid out the process, there would be somebody who was pegged with drafting a rule, then it would be open fire on it. And so it seemed like every rule was contentious, ones that you never even thought would be. But I think we had a lot of discussions on some things, interesting neutrality. What is the status of neutrality? Certainly, how does it apply to outer space? Does it apply to outer space, I should say? All those things. I never imagined I would be talking this much about neutrality a couple of years ago. Now we're talking about it again with some more frequency. But that's one that really stands out. But also just debates about or discussions about quantum of harm when you're doing proportionality analyses. How does that apply to outer space? All those types of things. I think there are a lot of different views and a lot of well-founded views. And actually, as Professor Blank noted, there were some areas where there are just fundamentally different views if you take a 100% international space law view, like for instance, the rescue and return of astronauts versus the law of armed conflict. So when you have those just completely differing views, both people can be right, but that doesn't mean you have a resolution that is readily available. So those are just a couple areas that I can think of.
Like you experienced, we experienced challenges on almost everything. Sometimes it was the big stuff like peaceful purposes. Sometimes it was mundane stuff like the definition of a space activity, like the discussion the last panel about is looking at space from the Earth. Space activity. Well, what about lasing a satellite from the Earth? Is that a space activity? Other mundane things about the liability convention and how that relates to other means of seeking remedies. Sometimes when you least expect it, you have hours-long arguments.
Would you say there are any issues of contention that particularly stood out to you, or things that you were surprised by in the process?
Yes, I was surprised by one particular topic. It was about the scope of the responsibility of states for national activities in outer space, and more particularly the attribution to states of the conduct of non-governmental entities. And that rule, I don't know if it is the case for the MILAMOS project, but needs for us many time and contribution from many experts, because the issue was to determine whether particular activities by a non-governmental entity involving the threat or use of force relating to the use ad bellum would result in the attribution of responsibility to a particular state under the Article 6 of the Outer Space Treaty. And it was the same kind of issue we wonder about the use in Bello, and we spent many time to try to solve this question.
Yes, sir.
One comment. Yeah, all of the above. That surprisingly, definitions were extremely problematic. Like it's been mentioned, what's a national space activity? What is an activity in outer space? Because that determines whether certain articles apply or not. And a military space activity, if a commercial service provider is providing data or service to the military, is that a military activity as opposed to just a military satellite? And there's many nuances of this. So those were quite problematic. And I'd also like to mention that there were 3 issues in which we wanted to write a black letter rule. Issues I think are very important for the military operations, but no matter how long we argued and how much we parsed the words, we could not get consensus on those 3 rules. But we think that's still important topics. So there are 3 non-rules that will have commentaries, but will not have a black letter rule. So those are environmental protection obligations, GNSS interference, and laser dazzling. There was no way to find some type of consensus on the rule, but commentaries will still be written that explains, various legal issues related to that, different points of view, and that sort of thing. So you can look forward to that, and I look forward to that as well in the final manual.
It's like a fascinating read. So
It should generate conversation.
I'm sure it will. So what would you characterize as the primary target audience for the WOOMERA manual and MILAMOS? Is it pretty much the same? And who do you anticipate reading and making use of these?
Yeah, I mean, I think kind of further to the comments earlier, I think anybody who is interested in this segment can make use of it. Certainly, I work for the U.S. Department of Defense, and we have a lot of views on these things. So it will certainly factor into what we think, but it might be maybe less important in the U.S. DoD, but for a state that is maybe looking to develop its concept of space doctrine and how it uses space law, it might be very useful. It's certainly going to be useful as a primer for others in government. It's going to be very helpful for people who, again, it's a manual about the military uses of outer space. So for those who may be in a purely civilian capacity in the space sector, certainly understanding where the military is coming from, why we do some of the things we do, how we think about how the law applies, I think it would be useful to those folks. And then, I think space law is it's a really exciting thing that you can do in law school now. There wasn't an option back in the old days, when I was there. So, I think these manuals will be a very useful tool for those just trying to learn about this area as well. In a context certainly of military uses, but it really does cover all the core elements of space law.
And just for us as well, we anticipate a wide audience. And obviously the military, legal officers, policymakers in government as well, foreign affairs. We hope it contributes to some of the discussions at the UN Open-Ended Working Group and such forum, academic research. We think the commercial sector, some of them will be interested as well, because if they want to provide services to military and it's a lucrative market, they should be aware of certain issues. Civil society in general, folks that are interested in protecting critical infrastructure. So we foresee a wide use, but they may be interested in different aspects of the manual. Some may be interested in only a few chapters. Some may be interested in the black letter rules. Some may be interested in reading in great detail the commentaries. So we anticipate a wide use. We hope that's the case for both manuals.
Great. And Mr. Doucet, earlier you mentioned that there were kind of 3 different scenarios: peacetime, gray zone, potentially pre-conflict, and actual wartime. But we've got 2 manuals. So how do you see MILAMOS and then Colonel King and Lieutenant Colonel Dupenloup, how do you see WOOMERA addressing those issues with that potential gray zone conflict to the extent that they do?
Well, in our case, we basically go up to the point where an armed conflict is initiated. So that includes issues of potential interference, activities that may or may not rise to the level of use of force or armed conflict. We do address use of force because that's pre-conflict or potential precursor. So I anticipate that we will have overlap on those gray zone areas especially, but that's how we sort of drew a line. As soon as armed conflict begins, it's out of scope of our manual. It was, I think, easier for us perhaps than for your manual.
Yeah, I think, well, and certainly the WOOMERA manual will be addressing all three of those stages. And I think we had a huge amount of expertise, both in the application side and then the academic side with regard to the law of war and how it, you know, would or does apply in outer space activities. But to the gray zone, I think there's a ton of focus on that. And I think there has to be. If you look at least, you know, from the US perspective, if you look at all of our strategic documents, we are talking about competition across the domains, you know, strategic competition with, you know, primarily with China, but certainly with all kinds of other competitors. And it's that competition that drives how we look at our military space operations, just like all of our other operations. So there's obviously a lot of focus on that in our minds. And I think that is reflected in the manual as well.
All right. Well, when do you expect these manuals to be published? When can people go out and get the full things?
Well, for us, we have a target date of early fall of this year. So it's a couple of years late. If you had asked me this question a few years ago, the date would be different, but that's our aspirational date for now, for volume 2. We have the rules out already, so, but the commentaries require a lot of work as well, so.
And any status on?
Yeah, it's going to be one package. So you took a slightly different approach. So it'll be the final product with rules and commentaries. Right now, the editorial team is finishing up integrating all of those state comments, because again, that's kind of the bread and butter of how we're looking at this. So those are getting incorporated, and as soon as it's done there, it goes to the press, the Oxford University Press, who will ultimately be putting it out, and they have to do the things that they do to it, which will take some time. But, you know, my understanding is that'll be coming out. It'll be going to them in the near future. Hopefully they'll only need a few months. So, you know, later this year is the anticipation. You know, we're all very excited to see what it ends up looking like, you know, all those who participated and otherwise. So, you know, there's definitely eagerness, but we don't have a date fixed.
With that, I'd like to open it up to the floor. If there are any questions in the audience or online that you'd like to ask of our panel.
Yeah, Brian, thank you. We do have some questions online. Our first question will take a question from Giuseppe Monteperto, and he is asking, how much do you think these manuals are able to influence, right, the practice of states, and thus either indirectly or maybe even directly contribute to kind of the development of either responsible behaviors or maybe even more, you know, bindingly customary international law?
I can start with that. I think it's possible to influence state practice in the interpretation of the treaty, potentially customary international law as well. But there will be, it might be the case that a lot of the rules will, like we said, not say very much because they've been stripped down to the lex lata, and I think that will signify an opportunity to apply the rule, interpret the rule in ways that you can, as was mentioned yesterday, some strategic thinking on how you can interpret the rules. And also the commentaries will probably refer to the state practice or lack of state practice in numerous cases. And I think that's a big, big flag to opportunities to insert state practice where where it might be strategic to do so.
If I could. Yes. I'm Professor Jack Beard, the humble, beleaguered editor-in-chief of the WOOMERA manual. If I could add a few things to your presentation. A year ago, the first draft of the WOOMERA manual was distributed by the Dutch Foreign Ministry to all the foreign ministries in the world, with this rather unique thing that Matt mentioned, to have all these countries come and spend 3 days going over it and telling us what the states thought about the rules and the commentary that we got. So foundational to this document, when we talk about state practice, is something that a lot of speakers have mentioned, an undervalued thing, the negotiating history of the Outer Space Treaty, and the states that were involved in that had things to add to that. In any event, we went through this process, and you asked what disagreements there were. Well, some of the state representatives that were kind to contribute so much time and effort are amongst your audience here from the foreign delegations, right? So you can ask them. You can assume that the usual controversial things like extraction or exploitation of space resources just drew all sorts of attention, with a clear inability, as you all know, to decide which. There's a great dispute about that. So the manual obviously has to reflect that. But the whole point of the manual in focusing on state practice is to talk about what the lex lata is, and in terms of what it's going to be, how it's going to be shaped by state practice, not some person who happened to be born in China talking about it, but what the governments are saying right now. So the result of that is a document that is entirely shaped by the states and their view of our attempts to express the state views. So I can't give you the specifics of the countries and their particular arguments on it, because we promised confidentiality unless we can indicate in the footnote exactly who it is. But that Article 6 discussion that was mentioned there, this is a huge matter for our country and for space, and the relationship of Article 6 to all these Mr. Musks and Mr. Bezoses and so forth out there. And I think one of the questioners yesterday noted the unfortunately accurate story about this, and that is that the Soviets managed to get a term in there that makes us responsible for non-governmental entities. It is a useful thing that I would also recommend, that makes the manual, I think, a great resource. Is there are big parts of the Outer Space Treaty that were put there by the Soviets. They're important parts. They deserve the attention of the US military, because you can be guaranteed they will be turning to them. The Chinese are already down this road on Article 6 and complaining about the Starlink threat to their space station and so forth. So there's a lot in the manual that is already happening that goes on and defines the way that things are going to do, based on the collection of state practice, which isn't, it's not that it's entirely consistent, it's that we can express the different views. And I think on other ones, and I would, this is a long talk without asking a question. My question is going to be to Colonel King, and that is, some of the rules also have to reflect something that needs to be in a manual, and that is things that affect the US military that I think some people don't recognize. Earlier, I listened to Artemis discussions, and the discussion in Artemis about zones, whether you like it or not, has implications for the US military. And an exclusionary zone of any sort is going to be a difficult thing to reconcile with the Outer Space Treaty. Colonel King was, in fact, one of the principal authors working on the zones rule. So I conclude this, as far as when WOOMERA comes out, I'm but a slave of Oxford University Press. Okay, so they and the law lords there decide when it will come out, and we'll give you the results on that as soon as we can. But I would ask Colonel King to just illustrate this point. The rule in WOOMERA on zones is an illustration of more of what can't be done because of the contours of the Outer Space Treaty, and it has to have a completely separate part to talk about the law of armed conflict. So with that humble brief discussion there. I ask you, give them a flavor of your work on the zones rule. Okay, thank you.
You, Professor Beard. Yeah. So the zones rule, as mentioned, is one of many contentious things because, again, in both the military space and civil space, it's not a defined thing. And, we've had lots of talks about, analogy and how do you use analogy. And certainly I don't think anything automatically applies by analogy, but certainly as attorneys, that's how we think. But I think more important than analogy is looking at what do states do in the absence of a prohibition. And one example of that is the ADIZ, the Air Defense Identification Zone. It's a thing, though if you look closely at it, it's not really a thing. It's an area where we ask that if you're going to enter our territorial airspace, you identify yourself, you provide certain information. And so we took concepts like that, where, in space, as an emanation of our territorial sovereignty, you could ask for someone who, again, this is in the future, is going to be entering your territorial airspace or territorial or your land. You could try to impose some sort of notification and warning environments. So, that's one example. But as Professor Beard noted, as far as drawing zones and requirements and keep out areas beyond that, the options are limited. Certainly in the law of armed conflict, there's this concept of an area of military operations where, just as a matter of, frankly, safety for others, it is appropriate for the military or whoever is conducting military operations to assert some degree of control over an area, again, to keep out people so they are not injured by the operations that are going on. So that can be developed potentially in a space context. But as noted, there are some things that you cannot do. So, there is the free use and exploration. So you can't just, just declare an area off limits to an adversary under general circumstances. So there are some things in there that you can't do, but ultimately, for this role and for most of them, I'll jump back to what Professor Nasu said yesterday about how we have to think strategically about how the law works. And in that case, the we is governments when we are actually applying space law, not necessarily people writing a manual, though we certainly have to contemplate that. And the law can only take you so far. You have to know what your national policy is and what your commanders, or for a lot of these cases, your civilian leadership want or need to be able to do. And then you can help shape the law or articulate the law to enable those things to happen. And so one thing we're very conscious of in this manual is to not foreclose those legally reasonable options for leadership to take. And one example of that, I think, is the zones rule. So it talks about a lot of things that could be, but the black letter part is just a very limited discussion of what cannot be.
All right. Do we have any other audience questions?
So we do have a virtual question. It's contrasting the Talon manual with the MILAMOS and the WOOMERA manuals. And our questioner asks, so the Talon manual focuses primarily on use of force in cyberspace, rather than maybe some other aspects of law that are maybe relevant to cyberspace, such as human rights, intellectual property, and other similar areas of law. And so our questioner's question is, how will these manuals, right, MILAMOS and WOOMERA, will they address those other areas of law, or is it going to be focused more like the Talon manual on kind of a very specific direction?
Just for the MILAMOS, we do address some of those areas. I must comment on the human rights, because that was an issue that was raised as a potential rule, but we never got anywhere with it. And so it does not exist as a rule in the MILAMOS manual. But other issues of liability, dispute resolution, and things like that. So there are some other rules that are perhaps don't refer directly to military operations or military engagements, but I think are important as a as a foundation when you're thinking about policies for the military. And so some of that is there. Perhaps not to the extent that the questioner, would like.
I've got another question, just thinking about recent events and how the conflict in Ukraine in the past year has been described as the first commercial space war. Have there been any sort of late-breaking developments in state practice that have been incorporated into the draft manuals or that have had to be addressed in particular? And about Lieutenant Colonel Dupenloup, would you like to take that question?
I'm sorry, I have no word about it.
Anything from the other panelists?
No, things move too slowly for to have incorporated that.
Yeah, I don't think we've directly incorporated anything from that in there. Though I will say, I mentioned neutrality earlier. I think a lot of what's going on now reinforces the fact that we're not sure how neutrality applies. So it is reinforcing in that regard, but I don't believe it's been directly addressed.
Anything?
Yes, sir. So recently at kind of the most recent meeting of the OEWG at the UN, right, the Russian delegation submitted a paper with respect to the idea that law of war, law of armed conflict, IHL, right, whatever you want to call it, shouldn't even be referenced with respect to operations in outer space because of this right push that the Russian diplomatic team is making with respect to, I think, maybe a cynical interpretation of the Outer Space Treaty. But could you speak to that, panelist members, from the perspective of maybe MILAMOS or WOOMERA? Is this Russian idea valid? Are other countries signing on to it? And how would the manuals address that particular topic?
That's the question of whether it applies, whether IHL applies.
Yeah, so yes, sir, but mostly the idea that the Russians are putting forward with their particular documents and kind of statements at the UN on that particular issue.
How can I put it? I think since we were all participating in our personal capacity, we didn't have to, face squarely the positions that the governments might put forward.
Fair enough. Thank you.
I'm not sure it's directly addressed. But it is directly addressed insofar as the view of the manual is that the contours of how may be up in the air, but IHL applies in space. Military activities in space can happen. They do happen. That's consistent with the international law, the Outer Space Treaty, and otherwise. So to the degree that there is debate about that, I would say the manual would disagree. Though certainly Russia is, I'm sure that Jack would take their comments.
The Red Cross are strong supporters of international humanitarian law applying in space because it protects civilians. But I would note that the questioner is absolutely right. Both the Chinese and Russian governments say talking about LOAC legitimizes the law of armed conflict. However, in the OEWG working group, the Chinese representative had a copy of the WOOMERA manual, the first manuscript, and said that he didn't want to prejudice his government's position that they don't want to talk about LOAC, but he proceeded to criticize the WOOMERA manual, which is a thing we can all be proud of. And then he went on to say these terms, distinction, proportionality, these are very complex. Yeah, that's what the manual is about. That's right. So the manual has already pulled him a little bit out of the shell to talk about it, but I think that's going to be their continuing position, that they don't, that this legitimizes armed conflict. But that's certainly not the position of the Red Cross or the states that we spoke with at The Hague. There were no comments from any of those states supporting that position. That's all.
the manuals go about resolving the lex specialis issues of applying both international humanitarian law and outer space law when potentially there are situations when these two specialized bodies of law could potentially lead to different results.
We didn't have that issue, fortunately.
Yeah, I think we did have that issue, and certainly at the beginning of the process, it's interesting. International space law and law of armed conflict are both lex specialis, and there's actually a I mean, I know there's been some work at the UN on how to reconcile competing areas of lex specialis, and I know that this is where it's good to have really good international lawyers on the team as well. But I know these were discussions, and this notion. So certainly reconciling is, that's what you try to do as a lawyer. At the outset, you say there is no conflict here, right? Here's how this applies. Here's how that applies. But I think even in the end, I think the rules will reflect some degree of tension between, those who are, the law is international law is the least common denominator law, right? Because it has to be by the consent of all parties. And similarly, the rules that we have to be the least common denominator because it's what everyone who was participating can agree on is the black letter law. And so I think those tensions, I don't think it's possible to entirely resolve those until states resolve them. And I should say critical mass of states resolve those. But as far as the manuals go, I think we had to appreciate the tensions. We certainly talked it out. We tried to, avoid the conflict to get the rules as close as possible to some form of consensus, but I don't think there's any way to make it go away altogether, again, until states start, acting and saying why they acted.
I think we have time for one more question. If there are any coming in from online or any audience members have any burning questions for the panelists.
Hi, Wes Ferris, Asteroid Mining Corporation, USA. What connections, if any, were made between maritime law and the overlap with the Outer Space Treaty? Because for military and civil operations, it's two different things. It could be a real thicket. So was there any connections made between the overlap of, say, the law of the sea and the Outer Space Treaty within these? Thank you.
Not many at all to my recollection, because in my view, the analogies to maritime law are useful when space law doesn't answer the question or international doesn't answer the question. So if you want to know how you can answer the question when there's no answer, you might look to another domain like maritime law, and it can be very helpful. But it wasn't our job to try to answer those questions. We just wanted to assess where law is now.
Yeah, I'll jump on and agree that there's no automatic application. But I think one thing that for maritime law, at least in the high seas, looking at how states behave and perceive they can behave in the absence of a prohibition, that could be universally applicable. So we look for those areas of universal applicability, what states can and cannot do when not otherwise prohibited. And so it's useful in that regard.
Sir. All right, with that, I would like to thank our panelists. Gentlemen, you have all provided some tremendous insights into the process going into these manuals. And I think we're all looking forward to being able to see when they come out so that we can refer to these and get some good insights into the law that applies to military space activities. So with that, thank you so much for your time.
And on behalf of the organization here, thank you so much, not just for your participation in this panel, but for all the hard work that you've done and all that your colleagues have done to push the ball forward on this very important topic. I know it's been very difficult, it's been very time consuming, but we all very much appreciate all the efforts that you've made. So thank you.